All right, we will go on the record in the matters 24 TR 112, 25 CM 30, 25 CM 125, County of Burnett, State of Wisconsin versus Victoria Mott. The state appears through District Attorney Kevin Schmidt in person. Ms. Mott appears in person with counsel Joel Feliski. We're set today in this matter for the sentencing part of this case. We did have Ms. Mott here on August 14th, in which she pled guilty to violating a harassment injunction times 3 counts. We have 2 victim impact statements to hear today. We will move forward and hear those. However, I did just get a recent filing as of today from Ms. Mott in this case. I wanted to ensure that Mr. Schmidt had an opportunity to review that.
I did.
All right, I did as well. Although it is very difficult, just saying on the record, very difficult to get filings on the day of sentencings, especially when it's multiple pages. It's very hard to find time to read. All right, so Ms. Bauer, we have 2 victim impact statements. One may come at a time and sit at that black desk. You can state your full name for the record or your initials, whatever you prefer. And if you're going to read something, please read it slowly so that my court reporter can take it all down accurately, okay?
Christy Haskins.
Can you please make sure that the microphone comes down to you? Thank you. Okay.
Christy Haskins. Is that better?
Is that even working? Can you hit on the top of the microphone?
That's not working.
Oh, is it working?
No, it's red.
I think red's fine. Just tap on the tap or tap on the top. Yeah, it is working. So just bring it a little bit closer. You didn't get a new one for there apparently. All right. Okay. You may begin. And it's Christy, K-R-I-S-T-Y.
Correct.
Okay, thank you.
Your Honor, thank you for allowing me to speak today.
And I'm hearing already that it sounds emotional or like it has emotion. And so I'm going to just let you know, if you need time to stop, I'd rather you stop, take a breath, take as long as you need to compose yourself, because again, it gets difficult for my court reporter to understand.
I'm requesting that Victoria Mott gets full punishment for all violations she incurred. It's been proven that Victoria cannot accept any implications as she is not seeing the consequences in her actions. She repeatedly violates the restraining order against her, and yet nothing has deterred her from the fear or constant harassment she has put on this family. While we have been on this constant merry-go-round for the last several years with Victoria, we're hopeful that today, sentencing, that Victoria will finally see the hurt she has caused our family. My husband and myself, along with our entire family, had to deal with her showing up randomly whenever she feels like damaging property, also almost running over my husband on the property. Driving over our septic system, doing donuts in our yard, the constant fear of vandalism, physical violence that she had incurred on me. This is all we've endured is not easy to be explainable. Our family should feel safe in our home. It should not feel that our property can be damaged at any time of the day. Your Honor, we ask for peace. We would like to also request an extension on our restraining order for the maximum allowed or per your discretion. We truly hope that Victoria has time to reflect on what she has damaged, what she has done. We have both, me and my husband, have traveled many times back and forth from here to other properties that we had, leaving work, spending several days at the property on numerous occasions because we did not feel that it would be safe if we were not there, even with the security cameras that we put up. The defendant has proven her inability to acknowledge or to stop showing up. She continues to be there, even after, like right after we were in court. So I urge you to honestly sentence her to maximum penalty. No one should have to do this. No one should have to live like this. Not for just my sake, my husband's sake, my grandkids, and even my kids that are underage. We can't enjoy the property or properties around the area because of this. How would you like it if you're laying on your couch sleeping in the middle of the night and she drives around your property recklessly, screaming profanity outside the window? This is not one time. This is several times. She has not stopped. And I don't think she will until you honestly make her pay for what she's done. So I thank you for allowing me to speak.
Thank you, Ms. Haskins. I do have to address one thing. You did ask for an extension of your restraining orders. This is not the proper venue to ask for that. And plus, they are through 2027. So there's plenty of time to look and assess before you were to ask for something like that. But in the criminal case, I cannot go to the civil matter and adjust that. Okay, just letting you know that part.
Thank you.
All right, thank you. Mr. Haskins?
My name is Jason Haskins, and I am Miss Christy Haskins' husband. A lot of the stuff overlaps. Do you want me to go through it all again?
You may. This is your time to let me know what you want me to know.
So basically, starting on July 14th, 23, there was traumatic episodes with Miss Mott, and basically on our property, continually telling me how she's an independent woman, she doesn't need help. Very violent, always violent towards my wife, more so than I. going forward, that's not the property on County Road A. We spent the money on an ADT system with 5 cameras. The cameras seemed to always be in the position that didn't catch her, meaning she would go in the bottom door, the back door, slide in a bedroom window, however it may be. And I witnessed this once. I was in the bedroom where she thought my son would be because I had back surgery. So I was laying on his bed and I could hear a knock at the window. And my 16-year-old son had just gotten a newer used vehicle, which she did not recognize. So she's screaming through the window, "Who's in there? Who's in there?" And my son and I both woke up like, what just happened? Went outside. That is when she was driving erratically up and down the driveway at a high rate of speed. Stopped just 2 feet short of hitting me because I was not very bright. I stood right in the driveway with my hands on my hips, like, what are you doing? Didn't even let up till 2 feet and then finally stopped. Eyes were wide open. So whatever that indicates, I don't know, but wide open. So that was that instance. Basically, I agree with my wife. I don't feel safe going up there. She has many friends that have come on our property. Matter of fact, I confronted one of them, which JJ Lehman is the gentleman's name, and asked him why he was there. And he explained he was there for Tori. And I said, I don't want you on my property. I think right now you're trespassing. Let's call Burnett County and get them coming. Well. So we got in the argument and his girlfriend thankfully convinced him to leave. So we didn't have an altercation, but again, another fine instance of something that we're, I don't know, I own a property and I can't even use my property. My son lives on the property, and whether she shows up whenever, however, it should not happen. We have the restraining order, and it's, I swear to God, it's almost like it's a challenge. She comes there more now. So, and currently now her stuff's stored at the house, her dog's at the house, and her kids come and stay at the house. Now, I don't understand why. And due to the previous altercation she had with my son, I don't know why you would keep showing up there with all of your stuff. But anyway, that's where we're at with that. I probably, Your Honor, went up there from Hudson, Wisconsin, no less than 2 days a week for almost a year, just to deter this. Didn't stop her. As a matter of fact, she bragged to me that she was at the house when I was sleeping there at the house because I was downstairs. So I don't know what it's going to take, whether it's, jail time, whether it's taking care of the damages she's done, however it may be, it needs to happen. Previously in her life, she's gotten out of pretty much everything with a slap on the hand and just don't do it. And I don't think she's learned anything. So, I don't know if I'm really missing anything here. It basically just comes down to that. And before all this started, I tried to talk to her and help her through things. And then after I'm a strong, independent woman and I don't need help. Okay, well, you're not getting my help. So, and I guess the only thing I would like to say in reference to Tori, and hopefully she's paying attention, is spend more time taking care of your children, having a consistent job, not drinking, not doing other things, and you would be a much better person. And I think that's where we're at with all this. I don't know what else to say or do that would sway you any other way as far as what she could do to get better, to get back on track. So I guess that's it, Your Honor.
Thank you, Mr. Haskins. All right, Mr. Schmidt, argument and sentencing recommendation, please.
So I'm going to go back a ways because I think there's some important historical context for the court to understand why we are where we are now, as well as to give some context to the letter that Mott wrote to the court earlier, which I imagine was pretty confusing for the court if it didn't know the history.
It's not. For the record, I'm very familiar. This goes way back to, I believe, 2022 with Jordan Haskins and criminal charges. And then there was an injunction. And then quite honestly, I have had cases involving the Haskins in Washburn County. I've had cases involving Ms. Mott and the Haskins in Burnett County. I'm well aware, and I was just going to say, when you're done, I'm taking judicial notice of the 22 CF46 case with Jordan Haskins, as well as the other matters involving Mr. and Mrs. Haskins and Ms. Mott. But please, for the record, argue all that you're intending on arguing. I just wanted everybody to be aware. I have a really good memory and I recall the facts.
Sure. I'm actually starting in 2016.
2016.
2016,
Could go back to there, but I don't recall off the top of my head what happened in 2016.
you won't because there's no case associated with
Okay,
it.
then I wouldn't be aware of that.
No, I'm going to be talking about law enforcement things too you wouldn't be aware of. In 2016 is when Jordan Haskins, with his then significant other, Courtney Strunk at the time, purchased the property we're talking about here. They lived together until in 2021, the property was quitclaimed entirely to Jordan. They eventually split up. 2021 is also the first time we had a domestic case with Miss Mott and Mr. Haskins. It was a domestic DC and battery. Because of his limited history, it resolved as just an ordinance in this court. Another incident happened that was more serious in 2022. Victoria was still residing with Mr. Haskins. Without bothering to go into the facts, because I don't think that's necessary, it eventually resolved with Mr. Haskins entering a plea to a domestic battery and a strangulation. He went on a deferred agreement with the strangulation. He went on probation for the battery. The strangulation DJOC actually ends in like a little under a month. The term of probation already ended because it was probation on one misdemeanor. During the course of the case, as many domestic abuse victims try to do, Victoria Mott tried to recant her statement. Because we had body cam already back then, we pursued it anyways because her statement on the body cam at the time of the incident was so compelling and Mr. Haskins was so incriminating. During the course, they both did the CRA class to start contact before the case even concluded. When he was placed on probation, DOC, regardless of what the court orders for contact or no contact, can always do their own thing, what they think is safe. And when they have a domestic battery probation with a person also entered a plea to strangulation, they chose to do just no contact at the start until, hey, lay off the training wheels later. During the course of that probation, Jordan did continue to have contact with Victoria and he served some jail time for it during the course of that. About a year and a half into that, Jordan transferred the property to his parents on a quitclaim saying no consideration. 2 days later, all three of them, his parents and Jordan, filed for restraining orders. Jordan would abandon his restraining order while Christy and Jason would get their restraining orders. That's the restraining order we're saying is violated here. This restraining order is a little unique in that it doesn't just prohibit contact at residences. It names specific addresses regardless of whether they're your residence or not. And this is one of those addresses. Regardless, Jordan Haskins has continued to have a relationship with Victoria Mott, as evidenced by there have been many other of these reports, these referrals of these violation restraining order that we never charged because they were essentially Jordan admitting that she was there on his behest or Jordan asking, is there anything I can do to end my parents' restraining order? He's continued to live at the same property continuously, even after he gave it to his parents. He seems to have continuously lived there for almost 10 years now. Part of what I think the victims have alluded to, Mott avoiding camera footage so successfully, that's how. He obviously knows where all the cameras are. He can aid her in avoiding those. Regardless, when we got the first spat of those referrals for that kind of restraining order, they weren't as severe. We actually met my office with Victoria Mott back then in terms of her being the victim of the past domestic abuse case and explained to her Christy and Jason Haskins have nothing to do with your domestic abuse case. This restraining order through the full faith and credit clause, if you violate it by going to this property, because it says go to the property, even if you have Jordan's permission, is a violation, and warned her if she continued to do it, we would be filing cases. She continued to do it. We filed these cases. The behavior got more and more specific and targeted towards the victims, Christy and Jason Haskins. There's really no reason for it at all for her to be doing that, especially when she's continued to have this on again, off again relationship with Jordan throughout the whole time. That is why in this case, Victoria Mott has no criminal history. So normally you'd look at this and say 3 convictions and a recommendation for 30 days jail right off the bat with probation. Is that too severe? No. I think you've heard the impact on the victims back there, how much it's distressed them, how much unpredictability it puts into their enjoyment of their property. And I think it's necessary here because of the repetition. I wanted these 3 convictions to show the repetition, to lay the basis for habitual criminality if it happens again in the future. And I wanted these 3 convictions to show how serious it was. I think the 30 days jail is necessary to show. We know with first-time offenders, the most effective types of incarceration sentences are short ones, because you put them in too long, they create bad contacts, they create bad behaviors, they get new bad friends where they can hang out at bad places with. When you have someone who doesn't have that criminal history, the short-term shock jail sentences, studies show, are most effective. So that's why we're doing 30 days jail there. I think that's the best way to deal with that in this case. I think that the conditions of probation should definitely include something looking at AODA. I can't show in any of these that she was under the influence of anything. I know one of the victims has said she had wide eyes and they think that's involved. The only basis I know for it is the domestic cases we had in the past. She had used alcohol for those. In her statement where she tried to recant the second one, she talked about substance abuse issues. I can't think of any other way to explain her behavior in this case, in these cases with targeting these parents of Jordan Haskins. Nothing else makes sense. There has to be something either deeply related to substance abuse or to mental health. Something is going on there to explain why a person who is (31 years old is suddenly behaving in this manner, this consistently over this period of time. You'll notice with the counts that we charge in this complaint, there's actually a significant period of time that these all occurred across. They weren't 1 week, next week, next week. So for those reasons, I think the probation is necessary. I think the jail is necessary. I hope the court has the full context to get an idea of what sort of issues we're dealing at with Victoria Mott, because she shows evidence of substance abuse, of mental health issues. She herself is a victim of domestic violence. We know she's on again, off again, continuing with that person who has been convicted of doing that to her. There are a lot of complicated issues with her, and I'm hopeful the probation is going to be able to help with that, and the jail is going to be helpful with saying to her, like, these bad behaviors need to be punished. Just because you're traumatized does not give you carte blanche to traumatize others. I know that's something we see constantly in the criminal justice system. I can't think of a single defendant we've had over there who themselves has not been the victim of trauma in the past. I think a lot of people don't know that. So that's what my hope is for this sentence. Thank you.
Thank you. Mr. Felisky?
Thank you, Your Honor. In entering in this plea today, Ms. Mott is paying a price for her actions. She is accepting responsibility for them and is suffering the consequences. I agree with the state in that for someone who has essentially no prior criminal history, that in full honesty, looking strictly from the outside, a year of probation and a 30-day jail sentence may seem severe. I do want to clarify on the record that we are requesting eligibility for ankle monitoring. I understand that Ms. Mott has the funds available for that program. Just wanted to clarify that on the record. But I think that this is an appropriate recommendation of the Galleon factors. Ms. Mott actually was the one who proposed the 30-day jail sanction. I think jail is going to be very appropriate as a deterrent for future behavior, given the nature of this offense. And considering that she will be on probation for a year, she will be further supervised in the community. The community, Your Honor, will be protected from any further violations through this supervision by DOC. And the programming available to Ms. Mott through the department to address any potential mental health, substance use, trauma-related issues will allow her to address her needs. As I've provided in documentation to the court, she has already taken that first step and has reached out for an AODA and subsequent follow-up sessions. She is working forward on moving her life past these incidents, putting distance between herself, between the parties here at issue. She advised in the days leading to this hearing that she actually received an offer for a job out in Lake Elmo, and has considered the possibility of relocating to Minnesota entirely. Lastly, Your Honor, in reference to the letter that she had written and I had submitted to the court, I think what Ms. Mott wants to indicate very clearly to this court is that the relationships that she's had with these individuals have caused her a tremendous amount of pain. And I think going forward, her single goal, if she were to only have one, would be to not have any pain anymore. I think that this is an appropriate recommendation, and I would ask the court to follow it. Thank you.
Thank you. Ms. Mott, I do have your written statement that you filed here today, and I have read it, and I have highlighted parts in it. And off the record or on the record, I believe Mr. Schmidt has indicated the state has received that and reviewed that as well. Would you like to make a statement here today in open court?
No, thank you.
The court is going to take judicial notice of 23 CV85 and 23 CV83. That would be the injunction cases with Christy Haskins and Jason Haskins versus Victoria Mott. 22 CF46, because it is relevant and does pertain and has a connection with this case and other cases. The state of Wisconsin versus Jordan Haskins. The court is going to take judicial notice of 22 SC208, and that would be the incident or the case involving Christy and Jason Haskins versus Victoria Mott, the small claims matter. This court has sat on all of those cases. I was the judge on all of those cases, and I have heard, for the most part, what was recited by the state in its argument. The court was not completely aware of the relationship in 2016 with Ms. Strunk and how that occurred. However, the other facts, other than any just incidents that were reported to the police, the court was aware of. And this case is something like I can put a timeline with all of the things that have occurred, even though they are different cases. If we had one case separately, this may be less serious and not aggravated, but we have all of these cases that together, in looking at it, which the court can do, in looking at the history, the totality of all of the circumstances, the court can look at that in rendering judgment and making a decision in the case. I have reviewed your statement, Ms. Mott. It is very lengthy. There is no doubt in my mind that you have been a victim. You are a victim. There was domestic violence. There could still be between you and Jordan Haskins. The court was well aware of that back in the 22 SC case and then having the 22 CF criminal matter with Mr. Haskins. You have been a victim of domestic violence. But in reading your statement, and I'm not going to read it out loud because again, it is very lengthy, but in reading your statement, you feel like you're the only victim. Like it's that you have been the one who is seen, who has been unjust, that the system has been actually harming you and not protecting you. You at no time acknowledge and admit your actions and what you have done.
Towards the end of the letter, I did, and I apologized.
You, yes, you
And-
apologized, but that's just like a child that gets into trouble, that has a tantrum, that does bad things, that the parent then goes and reprimands, and then the child continues to say, but it's your fault, it's your fault, it's your fault, it's somebody else's fault, it's everybody else's fault. Oh, but I'm sorry. Get me out of trouble. Don't punish me so bad. It's not a true apology. It's not a true apology. If you truly felt that you have wronged the Haskins, if you truly took accountability and responsibility for your actions, it wouldn't be 3-4 years later that we're still dealing with the same conduct. I've said this before and I'm going to say it again. Your relationship with Jordan is toxic. It's toxic. And I don't know if it's Jordan. I don't know if it's you. I don't know if it's the both of you. It is toxic. And you say in your letter, I'm very well versed in domestic violence. I represented domestic violence victims for many, many years free of charge. You make a statement that the system should know that victims go back to their abuser. They continue to go back to their abuser. That is very true. It takes approximately 8 to 10 times for a victim to leave their abuser before they have enough strength to continue and to move forward. I get that. But there is also this cycle of joint abuse, joint domestic abuse involving both the male and the female, or whatever the significant others are. The fact that you say that in your statement, that the system should know the victims always go back. And I went back and I'm continuing to go back and I see that he can change and I want to be there to help him change. It sounds like you're playing the system. You know domestic violence, you know the facts. You've went through the CRA class, the Community Referral Agency class. You're spewing the things that you want the court to know or to take into account. I'm aware of those things. If you're aware of those things, you should have, you know those. You reach out to your advocate, you reach out to your friends, you reach out to your family. You don't continue to go back each and every time to the place that you were ordered to stay away from. That was plain and simple. Back in the 22 SC case, the small claims case, you were told to stay away from that house. Then back in the 23 restraining order cases, you were told specifically in that order in black and white to stay away from that house. I can't, and I believe I reprimanded the Haskins as well back then. I believe I told them the words that they cannot control Jordan. If Jordan is an adult and if Jordan wants to see you, that is for Jordan to do. They can't control him. He is an adult. They cannot control you. You are an adult. However, they can control, and this court can control whether or not you ever step foot on that property and you violated it. How many times? more than these 5 or whatever times are alleged here, more than that. I believe Mr. Haskins. I believe Jason Haskins when he says you were flaunting to him that you were sleeping in the same house. I believe him. I don't believe you. I don't find you credible because this has happened over and over and over again. And I had to be harsh with Jordan Haskins in his criminal case. I've held him in prison, or not in prison. Luckily, he didn't go to prison. I put him in jail 60 days, 90 days. I kept increasing those days so he can understand the significance of having contact with you anyway, because he had no contact, but then with you at this house. And when you go to this house, it's pretty much sticking your middle finger up at the Haskins. You're saying, I don't care. I don't care what you feel. I don't care what you think. I don't care that you own the property. I don't care that you support your son. I don't care that you do anything. I don't care that you exist. I'm going to do what I want to do. Because in that small claims case, there was criminal damage, there was damage to that property. You admitted so on the record of that damage. You admitted to try and pay for it. You admitted to try and work it out with the Haskins so you could pay for it, so it would go away. They more so wanted your behavior controlled, you away from that environment. They really wanted you away from Jordan. But they used the avenue that they could with regards to those damages and the eviction. That wasn't an illegal eviction. I sat on that case. I heard everything. That was not an illegal eviction. It is not. You had your time to talk. You did not. I read your multiple
Claim
pages.
deed wasn't filed for over a year after that.
Please don't
Your
stop.
Honor.
I told you to stop talking. Not your time to talk. I have so much empathy for domestic violence victims. And I believe that you were and could potentially still be a victim with Jordan. Again, I don't know. I'm guessing that this has never stopped. It has never stopped. You are addicted to this cycle. You are addicted to Jordan. You know he's not good for you. You know he's not good for your son. You know he's not good for your life, because look at where you are. Now you're a convicted criminal. I don't know what you had prior to this, but now you are a criminal forever and always. And Miss Mott, I'm going to guess, this is coming down really harsh on you right now, but I'm going to guess prior to Jordan, you were sweet and kind, and you were not retributive. You were not trying to destroy people's lives and their property and to do those things. Again, you and Jordan are gasoline and fire. Gasoline and fire. And if this doesn't stop, something more serious will happen. Something more serious will happen. Somebody could be injured. Mr. Haskins could have been hit by that car. You could have been here for a reckless homicide, substantial battery, multiple other crimes. If something were to have happened to him, he just had back surgery. And he should not have been standing in the driveway at that time after back surgery, but he thought he needed to do what he needed to do to protect his property. And I'm harsh on you right now, and I'm going to tell you right now, I'm going to guess that at one point in time, at one different case or another, the Haskins have thought that I've been harsh on them too. I have to look at the facts in front of me for the cases. This got out of control. Every single time you went over to that house, you made a choice to go over to that house, not only knowing it was against the Haskins' desire and their wish, it was against the law. It was against the law each and every time you stepped foot on that property. But not only did you step foot on the property, you did donuts, you did other things that caused havoc to that property, and it got you nowhere. It didn't get you any good. It puts you in the light of the person who is doing all of the wrong. If you and Jordan cannot stay away from each other, if you and Jordan must be together, it cannot be on this property. You cannot step foot on this property one more time. Miss Haskins at this last one could have been injured. And I did read in yours that you said that she was holding you down or they were pulling your hair. Well, they were calling 911 or calling the police. They were trying to get a perpetrator out of their house. You're shaking your head. No, you were.
They were blocking the door so I couldn't leave.
You should never have
I know,
been
I
there.
understand that, Your
Not
Honor.
ever, never have stepped foot on there.
I know, I
But
get
that was your 20th time. And you're not getting it. You're just not getting it. You're risking your life. You're risking your son's life. You're risking your future, your reputation, all of these things. And I have to ask, is it worth it? Is it worth it? Is Jordan Haskins worth it? Because I don't think he is. Not for you. And hearing the recommendation, and Mr. Schmidt was saying, well, 30 days, is that going to be too harsh? No, not when we look at the factors in those things. In his argument, I'm thinking, is 30 days too harsh? Is 30 days too lenient? Because it happened over and over and over again, and it escalated. And I believe, again, Mr. Haskins, when he says he made those trips multiple times a week to try and circumvent this, to try and stop this, so you wouldn't have a clue when he was there. And I do believe his speculation that when he was sleeping in Jordan's bedroom, there was a different car there that you didn't recognize, and you thought it was another woman. And you went berserk. You went crazy. You did donuts in their yard. You could have been charged with criminal damage. On multiple occasions. So I have to look at this and I have to craft a sentence because this is serious. I have to craft a sentence that looks at you now, that looks at your past behavior, that tries to look at the crystal ball for your future behavior. And I need to protect the community. That means everybody as a whole, but in particular, the Haskins and this property. And to ensure that you understand that you'll get it. You'll understand you cannot ever step foot on that property. Never. If you do, there'll be ramifications. The court in trying to figure out and get a sentence that will accomplish all of the things, I need to look at also deterrence. I need to deter you from continuing to do this. I need to deter you from doing this. This is not a general deterrence where I'm deterring others, unless if we're looking at people violating restraining orders. I need to make sure I craft a sentence that deters you from doing anything further. That if you do this again, there will be serious consequences. I cannot extend the restraining orders at this time as the Haskins has requested, as they have requested. However, I can again craft a sentence that can try and meet the objectives of the victims, as well as the justice system. So in doing so, the court is going to do 2 years of probation, because that puts this out then to 2027. That puts us out to the length of the restraining orders, or close to, a little bit over. That is the longest that this court can go for probation. And with regards to actually sentencing, I'm doing an imposed and stayed sentence. If I were to do a straight sentence, even the straight maximum possible penalty, that doesn't accomplish and won't accomplish more protection for the Haskins and having the hammer over the head to ensure that you actually understand it, that you're not going to do it again. I have 25 CM 30, which is count 6. And then I have the 2 other counts in 25 CM 125, which would be count 2 and count 3. In 25 CM 30, what the court is going to do is I'm going to do an imposed and stayed sentence of 6 months in jail. If you're revoked off of probation, you will sit 6 months in jail for that count. In 25 CM 125, count 2, I'm sentencing you to an imposed and stayed of 6 months in jail, consecutive to the other count. That means if you're revoked, you will sit a whole year in jail. That's a long time to have to think and to contemplate. For count 3, I'm sentencing you to 6 months in jail. That is concurrent to count 2, but consecutive to 25 CM 30. So again, if you're revoked off of probation, 1 full year of jail. That is a very long time. I am sentencing you to conditional jail on top of the sentence that I have already laid out. For 25 CM 30, count 6, 30 days of conditional jail. 25 CM 125, count 2, 30 days of conditional jail, consecutive to 25 CM 30. In count 3, 30 days of conditional jail, concurrent with count 2, but consecutive to 25 CM 30. 60 days of conditional jail. It hasn't been enough for this court to reprimand you. It hasn't been enough for this court to look you in the eye and tell you, stop, you cannot do this. It hasn't been enough for this court to tell you and to say, look, gasoline and fire. This is a very toxic relationship. It's a toxic relationship. It has caused not only Jordan Haskins to get into serious criminal trouble and to sit serious jail time, it has now gotten you into trouble, and you are going to sit serious jail time, which could be substantial if you violate your probation. While on probation, there will be absolutely no contact with Christy Haskins, Jason Haskins, or any of their family, including Jordan Haskins. So you'll figure that out. No contact with any of the properties, and that does include the properties listed in the injunction. 6050 Cherry Circle North in Hudson, 26996 County Road A in Spooner, 702 Walter Street in Spooner. Absolutely no contact. If you think you need to drive to the grocery store and drive by one of those properties, I'd find an alternate route. I'd go 40 miles out of your way instead of driving by that house or one of those properties. I am also ordering a mental health evaluation and follow through. I am ordering domestic abuse programming completion and follow through. Absolute sobriety. No alcohol, no illegal substances. Gainful employment. What was the longest time you sat in jail?
I don't recall, 30 days maybe. I don't know.
So you have a criminal history?
I got a misdemeanor once years ago for paraphernalia for, it was over 12 years ago, I think.
Wow, 30 days in jail for paraphernalia. They took that
Well,
seriously.
no, it was literally, I got arrested and then I just sat until I was sentenced pretty much.
Okay. Well, 60 days will be no piece of cake. I'm going to give you 30 days to report to jail. So you have 30 days to get your affairs in order. I am not approving electronic monitor at this time. Consider that. But at least at this time, there needs to be punishment. House arrest, electronic monitor is punishment, but it's not the same punishment. It doesn't have the same deterring effect because then you can go about your normal life. You could have people to your place of residence. You could do fun things at your place. This is a deterrence. This is to deter you and to punish you from this continuous, ongoing, aggravated behavior. I will consider a motion for electronic monitor after 30 days. And again, why I am not considering electronic monitors, this county does not have the monitors that I would put you on. Because I want, if you are going to go on an electronic monitor, the county would need to order a different one because it would need to be one that is GPS, that is put right on your ankle, that cannot be removed. So they can see exactly where you are at all times. The court is ordering $443 in fines and fees for the count in 25 CM30, $200 DNA surcharge for the other 2 counts in the other case. I'm waiving the other court costs and fees. I don't think a financial punishment will have the same deterrent effect as having the jail time. I'm ordering your DNA. You must go to the jail and provide your DNA. You're going to need to have minutes so they know that you are not to be put into jail today, that you have 30 days. So when we're done, you need to come and get the minutes so that you can go provide your DNA. You would have the ability to request it be expunged through a written letter to the Department of Justice, not to the court, to the Department of Justice. The ticket matter is now dismissed as well and read in. You will have monthly payments beginning in November to be paid by the 15th of each month of $50 a month to be paid towards your court costs and fees. If you fail to make your monthly payments, you could get a warrant and sit an additional 6 months in jail. I'm going to have Department of Corrections collect that since you will be on probation for the period of 2 years.
Your Honor, so what's the grand total that I will owe? If you could.
$843.
Okay, I can pay most of it today.
Well, I do appreciate that. How much can you pay today?
I'll pay $450.
$450. If you can pay $600 today, I'll waive the rest. But I can't waive anymore because that's all mandatory. You
I'll
can
do
pay
it.
600? All right, so I will only assess $200 DNA surcharge per count, total of $600 to be paid today. And I'm doing that again because the financial aspect is not the punishment. The punishment is the jail and the potential significant substantial jail if you violate. I don't know if she has, I don't believe she has jail credit for here. Mr. Schmidt, what is the court missing? If you fail to pay, not only will a civil judgment be entered against you, you could sit up to 6 months in jail. Mr. Schmidt,
Nothing from me.
Mr. Felisky,
Nothing further. Thank you.
Ms. Mott. I want you to understand what I see and what I understand. And I believe to some extent the Haskins may have an understanding of this either, or too. Jordan Haskins is not 100% innocent in this. You have been a victim of him as well. He has asked you to go to the house. He has played a part of this. But you are the one who had all of the risks, and then you escalated it with Mr. and Mrs. Haskins. They're parents and owners of a property that are trying to do right. You are an individual in love, and you are blinded by that. Ms. Haskins or Ms. Mott, you need to, I say need, and you should respect yourself more. This is not something that you should want to be involved in. This is not a relationship that brings you happiness. It is not a relationship that brings you stability. It has only caused destruction and devastation for both of the families. I don't have a doubt in my mind that you are a good mother. I read it in your letter that you are giving your son stability right now while you're going through instability. That's a hard choice to make. I have a good feeling that once you're able to disconnect and get away from Jordan and to get some therapy, you're going to be a different person. And I don't think the Haskins are going to have to worry about that. You have to recognize your worth. And so far, you don't believe you have any.
Your Honor, in light of Ms. Mott's advice to me regarding potential property remaining, a personal property of hers remaining at Haskins property, we are asking permission for one visit accompanied by law enforcement for her to retrieve her personal items.
I don't believe I can do that in this order without the Haskins' approval of having law enforcement and having a visit to go there. I can ask them if they would approve of one visit with law enforcement present to retrieve any belongings she may have there.
I'm just mainly concerned about my grandma's things that are still there.
Sounds like she has personal property of her grandmother's that is still there. Would she be able to retrieve that with law enforcement, Mr. Haskins?
I can't.
And you may still be present.
Yeah, that's fine.
Yes. You may do so within the next 30 days. All right, before you turn yourself into the jail. And you need to make sure that's prearranged with the law enforcement. And Mr. Felisky, I'm going to say that it needs to be prearranged with you and Mr. and Mrs. Haskins. Okay? That's okay, Mr. and Mrs. Haskins, to speak with Mr. Felisky about that? Okay. All right. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I believe that covers everything. And we are adjourned. Thank you.
Thank you.